5 seconds to go. Start. Due to inability to get a treatment, the appellant became invalid from labor work, and that resulted in appellant developing a grudge against PW1 and his father deceased. Stop. Thereafter, on seeing the deceased coming towards the tobacco shop of PW3 on 6 September 2006, the appellant stabbed him on the chest and abdomen, causing grievous injuries to him, which ultimately lead to the death of the deceased. Stop. Para. The contentions raised by the appellant are on the weaker side in relation to testimonies of prosecution witnesses, as it has been contended that PW1 to PW4 are the supporters of Telugu Desam party, and their evidence were contradictory with respect to the nature of injuries inflicted upon the deceased, place of occurrence, etc. Stop. The testimony of a witness in a criminal trial cannot be discarded merely because of minor contradictions or omission, as observed by this court in Narayan Chetan Ram Chaudhary and another versus State of Maharashtra, wherein while considering the issue of contradictions in the testimony, while appreciating the evidence in a criminal trial, it was held that only contradictions in material particulars and not minor contradictions can be a ground to discredit the testimony of the witnesses. Stop. In paragraph 42 of the judgment, it has been held as under para only such omissions which amounts to contradiction in material particulars can be used to discredit the testimony of the witness. Stop. The omission in the police statement by itself would not necessarily render the testimony of witness unreliable. Stop. When the version given by the witness in the court is different in material particulars from that disclosed in his earlier statements, the case of the prosecution becomes doubtful and not otherwise. Stop. Minor contradictions are bound to appear in the statements of truthful witnesses, as memory sometimes plays false and the sense of observation differ from person to person. Stop. The omissions in the earlier statement, if found to be of trivial details, as in the present case, the same would not cause any dent in the testimony of PW2. Stop. Even if there is contradiction of statement of a witness on any material point, that is no ground to reject the whole of the testimony of such witness. Stop. Para. The same view stands reiterated in the concurring opinion expressed by this court in State of MP versus Ramesh. Stop. Para. The facts and evidence in present case has been squarely analyzed by both trial court as well as the High Court, and the same can be summarized as follows: para. The prosecution has discharged its duties in proving the guilt of the appellant for the offence under section 302 IPC beyond reasonable doubt. Stop. When there is ample ocular evidence corroborated by medical evidence, mere non-recovery of weapon from the appellant would not materially affect the case of the prosecution. Stop. If the testimony of an eyewitness is otherwise found trustworthy and reliable, the same cannot be disbelieved and rejected merely because certain insignificant, normal or natural contradictions have appeared into his testimony. Stop.